Hello, I'm Judge Steele, and I want you to know it's really a privilege to talk to you about this very important issue, your children and the courts. Now, your children are your children. If they're infants, if they're adults, if they're teenagers, whatever it is, they're your children. And every judge has sort of a different point of view on how children interrelate with the court system. So it's really important that you know what your judge's position is on how to handle kids in the courtroom. To start, as a general rule, do not bring your children to court. That's just the general rule. Unless the court tells you to bring the children, or you've been served with a subpoena to bring your children, and you have to bring them. Otherwise, don't bring them to the court until you know you're supposed to. Court is for adults. It's where you're the parent, and you've brought a question for the court to make a decision about. You need to protect your children from being involved in this process. Now, that's under a rule we call EDCR 5.40 if you want to look it up. Next, do not let your children read any court paperwork, motions, or statements by yourself or somebody else. Don't let them hear discussion about what's going on in court or tell them what's going on. Don't tell them what happened in court today. Don't let them watch any videos of a court proceeding, or don't ask them to write a letter to the judge. This is Rule EDCR 5.03. in case you want to look that up. Judges take your children's best interests very seriously, as I'm sure you do. They don't want any harm to come to your child. The court procedures are already hard on a child. Your judge will want to shield your child from further harm. Remember, your judge will not be impressed if you bring your children to court without court permission. If you believe your child must be involved in the proceedings, or if you think your child has some critical information about your case, let the court know about your concerns. After evaluating your case, the judge might give instructions about your child's involvement in the case. For instance, they might assign a CASA to your child or an attorney for your child. They will assess whether or not your child is old enough or mature enough to be interviewed on any level of the case. Have your child interviewed by a professional or by the judge would be one thing that they could do. They can have your child undergo a custodial evaluation if necessary. Or they can have your child undergo a mental health evaluation if that's found to be necessary. These are the decisions the court will make. Let the court know early so they can make the right decisions about your child. And the court will need some things from you about your child. They're going to know if they have the right to make a decision about your child. So they will need you to tell them where your child lives and how long they lived there. And you'll need to tell them if there's another state out there who already made a decision about your child. So be sure you let the court have that information. This is EDCR Rule 5.39 if you want to look that up. If another court has made a decision, the court will want to see those records early, especially if the other court is a child protection court. Finally, in the event that you don't follow these guidelines and you bring your child to court, you could be in trouble. You can have sanctions of up to 25 days in jail and $500 in fines. That's called a contempt motion. So try to steer away from that. The court can also strike your pleadings, and that way you don't have a voice in the case. So this is really an important section. Remember, don't bring your children to court unless the court asks you to do so or gives you some information about what your child should do to be involved in the case. And I really want to thank you for taking the time to watch this video. It'll help to improve your participation in the court system. It'll be helpful for your child. Good luck.